Good morning, everyone. Today we will be talking about the chapter Arrest under BNSS. Here, from section 35 to 62 of the BNSS talks about the arrest. Now, let us know what is the definition of the arrest. Here, the arrest means depriving the liberty of a person to move freely in the society is known as an arrest. See, there is a difference between an arrest and a custody. Now, arrest is done through a lawful thing, because the lawful thing is nothing but it is under the law. But custody is not like that. Any person, if a person is under the control of any parent, by the children are under the custody of the parents, patient is under the custody of the doctor. Here, the liberty is not deprived by these name as custody. But in arrest, it is not like that. When arrest is done compulsory, the person's liberty is totally deprived by the law. Means that person cannot move freely in the society. So arrest can be done with the handcuffing and without the handcuffing. But according to the Constitution and the Fundamental Right of Article 21, the handcuffing is an exceptional case. If the offender is damaging any other person or any other property, or the offender is absconding from that place, then with a reasonable reason, compulsory the police officer who has the authority to for an arrest of a normal person or of an accused is compulsory that the handcuffing can be done. But here the arrest can be done with warrant and without the warrant. As you know that normally the offences, the offences are divided into two. One is cognizable offence and next one is not cognizable offence. Now what are the cognizable offences? The cognizable offences are the offences which are rigorous and which causes a person's death or any gang rape, trespass, dacoity, etc. all comes under the cognizable offence. That is your first point. And when you come to second point, it clearly says that any punishment which is rigorous and which is of the punishment is more than 7 years, then we say it as a cognizable offence. When any offender makes any cognizable offence, the police officer who has the authority to arrest, who is also known as a civil servant, has the right to arrest the person, the offender, that is without the warrant. But when we come to what is non-cognizable offence? When we come to non-cognizable offence, the offences which are less seriousness in nature, it clearly says that less seriousness in nature, and where the punishment is less than 7 years, then it is known as a non-cognizable offences. In all the non-cognizable offences, it is compulsory that the police officer who has authority to arrest the offender can arrest with the warrant. It is compulsory that the warrant is compulsory to arrest the person who has done a non-cognizable offence. How can you differentiate whether it is a cognizable and non-cognizable? See here, when the police officer who is a civil servant who has been trained in the job, that by seeing the offences or by knowing the offences or by the act which is done in the society is clearly distinguished by the police officer whether it is a cognizable offence or a non-cognizable offences. So actually what is an offence? Offence is nothing but which is unlawful, which is unconstitutional, where any bloodshed is given, bloodshed is there in any of the act done by the person who is known as an offender is known as an offence, which is clearly talks about in PNS, that is old IPC, what is the punishments and what are the sections which are concerned to those offences. Now here, why when it is a cognizable offences, when a police officer has a right to arrest, can without warrant can arrest? Because it is in a cognizable offence, the offender who has completed the act may abscond, or the instruments which are used for the cognizable offence may be also destroyed. So a police officer, without going to the court, first the arrest will be done and then applies for the warrant to the court. So every arrest compulsory warrant is compulsory. But when we come to the cognizable offences, as the offence is very serious, it has to be taken into consideration that without the warrant also, the police officer has the right to arrest the person. But when it comes to non-cognizable offences, it clearly says that the police officer without compulsory has to go to the court, take the warrant, then only the person has to be arrested. Now, arrest can also be done. This comes under the section 35. When it comes to the 38, when any offender or does any offence, it is under section 38 clearly says that the offender has a right to meet a advocate for the further trials in the court. But when we comes here in section 39 of BNSS, it clearly says about that arrest is nothing but if any person where the police officer feels that the person is included directly or indirectly in the offence, and the police officer needs the address and age or the name of that person. If the person refuses to give the name, address and their occupation under section 39, the police officer has a full right to arrest that person. In a simple phrase, we say that refusal of the person to give the name and the address to the police officer. Now, arrest can be done by three persons. Arrest can be done by the private person also under section 40. Arrest can be done by the magistrate under section 41. And arrest can be made through the police officer who is an authorized person to stop or to prevent or to arrest any of the offender. Now, arrest by a private person. How a private person can be arrested? The private person also has a right to arrest a person, but not using any handcuffing or not using through any of the authority. For example, a person has done something wrong or illegal in front of us. We can stop that person, we can prevent that person to do that offence and see that the person is kept in a place where the person cannot be abscond or the person cannot do any property damage or any other person. Then the private person has a right to give the information to the police officer through any of the mode of communication. Till the police officer comes, it is a duty of the private person to see that the offender is under the custody of that person. That can be done in the name of the private person. When we come to the arrest by magistrate, when within the place of the magistrate, if the magistrate has a knowledge of doing any act done by the offender, the magistrate also has a right to inform the police officer, and in front of the magistrate, the police officer has a right to arrest that person under the section 41. Now we will talk about how the arrest is made. When the police officer comes to know about the act or the offence and the offender is within that premises, the police officer will go to that person and clearly says that what offence the person has done, touches the body, the police officer will touches the body and say that the person is under arrest, and when the arrest is done, compulsory under which offence the person is arrested, under which section the person will be punished, or under which jurisdiction of the police station the person will be taken into the custody. So these are the things which has to be said by the police officer to that offender, then the arrest can be made under your section 43. Next, when that police officer arrests the person under section 43, the same police officer also has the right to search the person for any weapons which are being kept within the body, like any instrument which is used for that act. If it is a murder, any instrument like any knife or any blade or anything which is kept, which is placed within that offender. Then the search of that place, the person where the person has been arrested, or the search of that person itself, the offender, can be done by the police officer. Any instrument which is found within that place or any instrument which in the body it is found by the police officer, under section 44, the police officer has a right to seize all the instrument which is related to that offence and can be taken into the custody. All those instruments can be taken into seize and it can be kept into the custody. Now, when arrest is made, it is compulsory that the offender or the arrested person should know should be known about all these under the following sections. Now let us go to these things which is known as rights of the arrested person. First, now under which section the police officer has arrested the offender, under which jurisdiction, that is police jurisdiction, the police has been taken, and should be known to the accused for under what offences it has been done. And next one, under your section 48, it also talks about that it also gives information about the friends, the relatives and the family members. Under which section the person is arrested, under which jurisdiction the person is arrested, under which section it has been under your BNS, that is under your IPC. Next, under section 49, the search of the accused person also is done, which is already has been discussed. Thus, the search of the place or the search of the person itself will be done by the authority. Here it is authority is nothing but the police officer. The police officer will search under your section 49. Now let us go to the 50. Under section 50, it is the police officer has the power to seize any instrument which is related directly or indirectly for that offence the person has been used to do that act. That all the instruments are also be seized by the police officer, which will be taken as evidences in the court at the trial process. Now we will go for the 51. When the person is arrested, the person will be knowing, the offender will be known under which section, under which jurisdiction they have been taken, and about the arrest of that person, the family members, the friends or the relatives also will be given the information. Next, a medical examination of the arrested person will be done. The medical examination will be done by a surgeon or by a doctor of a civil servant who is a doctor in a government hospital and a member of IMC, that is Indian Medical Council. The doctor has a right to examine the body of that accused and the report will be submitted to the police officer. That will be done under your section 51. 52. Now, suppose if any accused is arrested under the rape, if it is in a rape victim, then the examination and the report will be done in camera. Okay, it has to be done by the medical examiner and the report should be submitted by the officer, that is the doctor or the medical officer, to the police officer under your section 52. Next, we will be talking about under your section 48, it says that when the police officer arrests an accused, he or she has to be produced to the person before 24 hours before the magistrate. This is compulsory. Now, if the magistrate, if the police officer does not produce the person within 24 hours, the offender has a right to file a writ under Article 32 or 226 in High Court or the Supreme Court, the habeas corpus writ. Now, what is the habeas corpus writ? Habeas corpus is a Latin word which is known as have your body. So, it is compulsory that when a person is arrested, the person has to be produced before the magistrate within 24 hours. But there are some exceptional cases. Suppose a person has done an offence in Hyderabad and within the period of the arrest, the person has been absconded to some other place. Then the police officer has a right to take the arrest warrant, search warrant as well as the seize, then go to the place where he will be made available and the arrest can be done by the police officer, and it is very difficult to see that within 24 hours the police officer has to produce the offender within the court within 24 hours. Then in these exceptional cases, the police officer will arrest that person wherever he is available. So if it is necessary, search and seize also will be done, and compulsory it is within that jurisdiction if the person can be arrested. Okay, the last one under your section 57 of your BMSS, it is compulsory that after arrest, the offender has the right to meet the advocate to meet an advocate for his defense. Or if the person is not financially supported, they can give a free legal aid which is available within the premises of the court.